And I left the file on my desk. Wouldn't you know it?
I could have got it.
Okay, Shannon, put us on the record now.
Go ahead.
This is a matter of J. Mason Contracting versus James Jaros et al. So, counsel, state your appearances and please identify your clients or witnesses who are also present.
Good morning, Your Honor. Christina Fisk on behalf of the plaintiff, J. Mason Contracting. Present with me today is John Mason on behalf of J. Mason Contracting. Also present in the courtroom right now is Topher Clark. He is actually a rebuttal witness for me. And then I have one other rebuttal witness later today when the need arises by the name of Martin Brisky.
All right. Well, right now I'm only concerned with the people that are actually here. I just want to make sure everybody's identified. Go ahead, Mr. Thompson.
Morning, Your Honor. Kevin Thompson appearing on behalf of the defendant counter plaintiff James Jaros, who is the trustee of the James Jaros Revocable Trust, owner of the property at issue in this matter. He is present today together with his wife Stephanie. They're in the conference room with me. And I also have my administrative assistant, Ashley Smith, here with me to assist me with the IT matters that I'm concerned about. So those are the ones present at this time, Judge.
Thank you. Do either of you wish to make an opening statement?
Myself. Your Honor, I'm going to waive that in light of the fact that we submitted trial briefs. I think we can move forward.
Fair enough. Mr. Thompson?
Judge, I'm just going to say very briefly that this is as I said in my trial brief, this is simply a tempest in a teapot where two fairly strong personalities did not get along during the course of a construction project for issues that the proof and the evidence will make clear. And that it's never been an issue that Mr. Jaros does not have the ability or the wherewithal to make payments that are contractually due. They've always been willing to pay contingent upon satisfaction and completion of the contract. And so it's simply the position of Mr. Jaros that he is not defaulted in any fashion and that he performed in accordance with the requirements of the contract drafted by Mr. Mason and upon which the four corners of this construction project proceeded. And with that, that's all I'll have to say at this time, Judge. Thank you.
Okay, go ahead, Ms. Fisk.
Your Honor, I think preliminarily, I do also want to make note of the fact that Mr. Thompson and I did jointly present to the court exhibits. And we have them all marked just as plain exhibits. So there's no plaintiffs or defendants exhibits. We agreed upon these ahead of today with the exception of exhibits 18, 19, 35, and 36, which I did advise Mr. Thompson. I did have one objection only to the extent that these shouldn't be used unless the person who drafted them essentially is called a witness. So effectively, it's my understanding that Mr. Thompson and I have agreed to the admission of the other exhibits to circumvent some procedural issues today.
All right, exhibits 1 through 38, with the exception of 18, 19, 35, and 36, are admitted by stipulation.
That is correct, Judge. And you have those actual physical exhibits marked in front of you as well? They've been delivered to your, at least I delivered mine. I assume Ms. Fisk delivered hers as well.
I do have them.
Perfect. And then as far as the witnesses go, I know that my client, Mr. Mason, Kevin, has his exhibits in front of him. So I don't know whether or not you have paper copies for your client. I will certainly share my screen as necessary. If I need to, just let me know that.
Yeah, we have paper copies as well.
Okay, perfect.
Thank you.
And Your Honor, would you like for me to share my screen when I'm referring to an exhibit, or do you want to just let me know if that's something you need me to do?
I don't think, unless there's a question or a specific provision you need to draw attention to, I've got the copies in front of me, so I'm fine with that.
Okay, sounds good. All right, Your Honor, in light of that, I would like to call James Jaros as my first witness.
You'd like to call James
Okay.
Jarrell?
Yes,
He's gonna come sit down next to me here. We got cords here to deal with as well.
Mr. Jaros, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down, state your full name for the record.
Name's Joseph Jarris.
Go ahead, Ms. Fisk.
like Mr. Jaros. You are the trustee of the James J. Jaros Revocable Trust, correct?
Correct.
Christina, we're having a hard time hearing you.
You're having a hard time hearing me? Okay.
Yeah, your volume has kind of bounced up and down. I turned you up, and then it started coming through really loud, so I had to turn it back down again.
Let me try something. Hold on a second. All right. I'll try putting my headphones in, Judge, just a second. Does that sound better?
That did.
Okay. Clear?
Go
All
ahead.
right. Okay. So you are the trustee of the James J. Jaros Revocable Trust, correct?
Correct.
And the James J. Jaros Revocable Trust is, in fact, the owner of the real property located at 1094 Santa Monica Drive in Brooklyn, correct?
Correct.
The property was purchased by you through your trust in November of 2017.
Correct.
And that property includes a small lakefront cottage on Vineyard Lake. Is that right?
That's correct.
Shortly after your purchase, you undertook efforts to remodel, correct?
Correct.
In the spring of 2018, you hired J. Mason Contracting for that remodel project. Is that accurate?
Correct.
I would like for you to pull out, if you could, Exhibit 1.
All right. Here.
Okay. Exhibit 1 is your contract with J. Mason Contracting. Is that correct?
Yes. Just to be.
Okay. The first 2 pages are your initial contract dated March 16th of 2018. Is that right?
That's correct.
And your signature appears at the bottom of both of those pages. Is that correct?
Yes, that's correct.
Now, the third page of Exhibit 1 is a document entitled Terms and Conditions. Do you see that?
Another what?
Terms and Conditions, page 3.
Yes, I see.
Okay.
So, let me interrupt. I am able to hear, but it would help if we could improve the pickup just a little bit. I don't know if you need to be closer to the microphone or what, Mr. Jaros.
I can hear okay, Your Honor. There was just a cough in when the question was asked. There was a cough that drowned out the sound.
I can definitely hear you better now, so you may continue, Ms. Fisk.
Okay, thank you. Going back, Mr. Jaros, I'm referring to page 3 of Exhibit 1 entitled Terms and Conditions. Do you see that document?
I do.
And your signature also appears at the bottom of this, correct?
Yes.
And do you recall that this was attached to your contract with J. Mason from March 16th of 2018?
I do.
Okay. Now, the following pages after the terms and conditions, there are 5 additional pages. These consist of additions to the contract after March 16th of 2018. Is that true?
That's true.
And your signature also appears on each of those documents. Is that accurate?
It looks like it appears on all of them but for one. The last one.
And you're looking at, it looks like it's 5/21 of 2018, estimate number 816. The second page of that document, your signature does appear on the bottom of that, correct?
Correct. Correct.
Okay, so this is one estimate number 816, and you did sign this estimate, correct?
Correct.
Okay. Fair to say that this contract outlines the scope of work that you engaged J. Mason Contracting to complete for your remodel project?
Yes.
And J. Mason then did in fact undertake remodeling efforts for your project, correct?
Correct.
And you agree, don't you, based on this contract and the contents, that this remodel project was extensive? True?
True.
Okay. You had new wall framing, you had a new beam placed underneath that was encountered after construction started, new drywall, correct?
Correct.
Installed a new deck on the front of your lakeside cottage, correct?
Correct.
Okay. All new plumbing, all new electrical, right?
Correct.
Now, during the project, as we mentioned previously, there were some changes that were made to the original contract, right?
Yes, these were the changes here.
Okay. And some of those changes included you added a bathroom after the original contract, right?
No, there was always a bathroom.
Oh, you added a second bathroom, correct?
Just split the first one in half.
But you created two out of one, right?
Correct.
Okay. And there's as I mentioned previously, there's a main beam that runs underneath your house that had to be replaced, correct?
That's my understanding.
And some parts of the subfloor had to be, and the supports for that subfloor had to be fixed, right?
Yes.
And we mentioned that you added a dock, a fairly sizable dock, I think a 22-foot deck on the front of the house. Is that right?
Yeah, that sounds right. 22-foot wide.
And at some point during the project, you decided that you were going to take over a few aspects of work that J. Mason had been engaged for. Is that right?
Well, my memory is actually some of these items that were additions in May of 2018, we were going to undertake, specifically the deck. And J. Mason had mentioned to me that he needed additional critical mass to stay on site, needed to be more engaged on this project. So if he's doing, as an example, the deck, he could be there while others inside are working. He could jump in and jump out and be in more of an oversight position. So he needed more critical mass to stay engaged on this. So encouraged me, convinced me to sign, because we were talking about if he just put the footers in on the deck, we could do the rest of the deck. But he was basically saying he needed the critical mass. So I signed these to him to allow him to have that critical mass he needed to stay on site on my property.
But you could have said no, right?
Could have said no, but I guess the feeling I was getting, if I said no, then I was going to get a further delay in this. And we're already looking at going to lose the summer because he couldn't stay employed. I was not getting, I had asked for in March, I'd asked for a shower to be outside the back of the property. And the quote came, I met with
Hold on a second, Mr. Jarvis. I think you're getting a little off track. So my question is honestly just, did you, specifically you, at some point during the project, undertake or assume some of the work that you had engaged J. Mason to complete?
Not until we agreed to go separate ways in mid-July.
But you did agree to take over a few aspects of work, correct?
Yes, in mid-July of 2018.
Okay, and that included the flooring, both materials and labor, right?
Yes.
Which is a fairly large component of the contract, correct?
Correct. Can I say something? Can I say something?
Hold on. Mr. Jaros, let me explain the rules. When Ms. Fisk is asking you questions, you don't have the ability to ramble on and offer explanations unless she asks you for one. If she asks you a question that can be answered yes or no, you need to answer it yes or no. If you can't answer it yes or no, you can say that. At some point later, Mr. Thompson will give you an opportunity to elaborate if he thinks that needs to happen. But while Ms. Fisk is questioning you, this will go much smoother if you just listen closely to what her question is and answer that question. Don't go beyond it. Okay?
Okay.
Go ahead, Ms. Fisk.
Thank you, Your Honor. So just to back up, Mr. Jaros, you agreed that you would take on the flooring, both materials and labor at some point during the project, correct?
Correct.
And you also agreed that you would take over the bulk of the priming and painting, correct? With the exception of that was already done by J. Mason, right?
Correct.
And also you agreed that you were going to take over the installation of an exterior door, correct?
Correct.
Okay. Let's look at Exhibit 4.
Okay.
Do you recognize Exhibit 4?
Yes.
These are your checks paid to J. Mason on this project, correct?
Correct.
And these are actually in reverse order. So let's go to the third page, page 3. The first check, this is the first check that you paid at the time you signed the contract with J. Mason on 3/16, correct?
Correct.
And then the check above that on June 13th, 2018, this is your second payment to J. Mason on the project, correct?
Correct.
And then on August 8th, 2018, you made a third payment, correct?
Correct.
And you agree that the August 8th, 2018 payment is the last and final payment you've made to J. Mason on this project, is that right?
Correct.
And do you agree that these checks total $41,665?
Yes.
Do you also agree that these comprise all of the payments that you've made to J. Mason on this project?
Yes.
If you would now look at Exhibit 6.
Okay.
And do you recognize this as a sworn statement from J. Mason Contracting that was provided to you during the project?
Yes.
And the date of this is August 2nd of 2018, correct?
Yes.
And do you recall receiving this on or around that time frame?
Yes.
Okay. And the amount that's shown as currently owing, I'm going to direct you to page 1, and it is the second to last column on the sworn statement. At the very bottom, indicating the amount currently owing is listed as $19,395. Is that how that reads?
Yes.
Okay. And this August 2nd sworn statement predates your last payment of August 8th on this project. Is that accurate?
Of August. Yes, it's before that, before applying that.
Okay, so this $19,395 does not reflect the last payment of $12,070, correct?
Correct.
Okay. All right, now if we will look at, let me back up. Let's look at Exhibit 5.
Okay.
And do you recognize this as a claim of lien that was recorded against your property at 1094 Santa Monica Drive?
Yes.
And this is a claim of lien that was filed by my client, correct?
Yes.
And the amount of the lien listed down toward let's see, it's the 1, 2, 3, 4, 5th paragraph on page 1 indicates that the amount of the lien is $19,395. Is that correct?
Correct.
And that comports with the sworn statement that you then received on August 2nd or about August 2nd of 2018. Is that correct?
Correct.
Okay. And you were in fact served with this claim of lien, right?
I was.
Okay. Let's look at Exhibit 7.
Okay,
Do you recognize Exhibit 7?
I do.
This is a letter that you wrote to me actually on August 10th of 2018 in response to the claim of lien. Is that right?
That's correct.
If you would look at page 3 of your letter, about halfway through the page, there's some red typing. Do you see that?
Yep, I do.
And then the second sentence from that red typing, you write, the amount held back as of today's date is $6,995. Do you see that?
I do.
And that's something you wrote, correct?
Correct.
As of the time that you wrote this letter on August 10th of 2018, you agree, don't you, that at that point in time, you believed that you still owed $6,995 on the contract if all work was completed, correct?
Correct.
Okay, if you would look, Mr. Jaros, at actually, bear with me for a second. Mr. Jaros, on or about, let's say July 13th or mid-July, you and Mr. Mason agreed that he was going to leave the project prior to completion and that you were going to bear responsibility for completion of those things that we talked about earlier. Is that correct?
That's correct.
And that was mid-July, correct?
Mid-July, correct.
Okay, all right. I have no further questions, Your Honor, for this witness at this time.
Mr. Thompson, do you have questions now, or do you want to reserve them for your case in chief?
Just one question, or one area that we'd like. Mr. Giles, when you had that discussion with Mr. Mason in the middle of July to go your separate ways, did you agree to assume all work necessary to complete the contract, or was there some other work that needed to be performed?
There was other work that needed to be performed by Mr. Mason.
And could you itemize to the court what that work that Mr. Mason was required to complete?
There was plumbing, 2 toilets needed to go in, showers, all the connections on all those plumbing apparatuses, a water softener, which was part of to be supplied by Mr. Mason in my purchase price. Installation of the plumbing products and connection. So I just had open a hole in the floor where the toilet would go. So there's plumbing and then electrical. There was wires protruding out of the walls at that point in time. So there were no no appliances connected and just walls. So the home was not, I couldn't use it for toiletry nor cooking or couldn't stay there. It was not able to live there again.
The electrical connections were not finished?
Right. There was just wires sticking out of the walls at that, just the point we went separate ways.
Did you agree to, in fact, finish those electrical connections?
I did not. However, anticipating if Mr. Mason would not return, I went and obtained quotes to complete his outstanding work at that point in time.
Now, notwithstanding the need to hook the toilets that you had agreed to place the new flooring down, is that correct?
The new carpeting and yes, that's correct.
Did you have to complete the flooring before the toilets could be installed?
Not being a contractor, I'm not 100% certain whether they could go in before or after, but
Did you have that discussion, any discussion in that regard with Mr. Mason?
I don't recall having it with Mr. Mason.
Were there
So,
other,
repeat that. I'm sorry. Repeat that last answer. It got kind of garbled.
Okay, I don't recall having any conversation with Mr. Mason regarding what has to go first, the flooring or the toilets.
Thank you.
but nonetheless, it was your understanding from your discussions and parting ways with Mr. Mason that the toilets had to be connected, correct?
Correct.
Or installed, I guess is the word. Installed, I'm sorry. So were there other performance defects that existed in mid-July when this situation occurred?
Well, it became known to us, we didn't have much rain, as you can appreciate this summer, but it was observed that when it did rain, there was a gutter issue and the water was coming right off the shingle behind the gutter and dripping immediately down. So that was known at that point in time.
Was there anything else that was known at that point in time?
Nothing else at that point in time.
And was it your impression, based on your experience in construction and whatnot, that in fact, Mr. Mason was completed with the contract when you split ways in July of 2018?
No, he was not complete. There was those two big ticket items. We needed electricity and plumbing completed.
Were there any defects in the plumbing in July of 18 that required correction, as you recall?
None in July of 18 as it wasn't completed.
But it was certainly Mr. Mason's responsibility, either he or his sub, complete the electricity. Is that correct?
Correct.
And so ultimately then, when you received the final payment, what was your reaction? I'm sorry, when you received the final invoice, what was your reaction from that receipt of that invoice?
I was surprised because the pace of the project was slow, and we just agreed days before I received the invoice. We just agreed who's going to take over what, and then I immediately got a balance invoice for 100% of the final contract being due. So 100% of what what Mr. Mason thought he was due, he invoiced me for, and I said, there's all these open services to be done by you.
I'm going to show you what is marked as Exhibit 3 and ask you to take a look at that. So Exhibit 3 is a series of invoices, if I'm correct. And the top invoice is a compilation, is that correct?
Correct.
And it reflects properly the first two payments that you made as reflected on Exhibit 4 of the payment, correct?
Right.
And what is the date of the final invoice that you received from Mr. Mason?
July 24th, 2018.
And at the time that you received that invoice, Mr. Mason completed the items that you previously discussed needed to be completed.
He had not.
And was the project at that point, strike that question, had Mr. Jara completed his performance under the contract on the date of that invoice of July 24th?
Sorry.
Had he completed his performance under his contract as required on July 24th?
He had not.
And in fact, you ultimately sent a check, is that correct? And that's the third check under Exhibit 4, the check for $12,070, is that correct?
That's correct.
And you withheld some funds from that? You held back some funds?
I withheld some, which I thought was a fair determination of the remaining services yet to be provided, including that electric and plumbing. And again, I had those independent quotes that were higher than my withheld value. So I was of the impression that that was a fair withholding at that point in time.
The intent was what with respect to that final holdback of $6,900?
Was always to pay that once I got the final permit or final approval by the county saying the house is livable now. So once I received the final electric and final plumbing, then I would release the check.
And how soon after you received the invoice dated July 20th, 2018, did you receive the claim of lien?
Sorry, July 24th.
July 24th.
Oh. Once I received the invoice on July 24th, the lien was filed within 1 week. I got a sworn statement on August 1st that I just said appeared to be incomplete because only 2 suppliers were listed. And so I got noticed that within 1 week. I didn't formally get served until August 10th is when I was able to sign the paperwork. So I formally got notice on August 10th that a lien had been filed.
When you received the lien on August 10th, it was already recorded, is that correct?
That's correct.
What was your understanding that on the date that the lien was recorded?
August 2nd. Was
the claim of lien, the recorded claim of lien, when it was served upon you, had you received any lien waivers at that date from Mr. Mason?
I don't recall receiving any lien waivers, just a sworn statement.
Had you requested lien waivers prior to that date from Mr. Mason?
I did. My first request was on June 13th when I mailed Mr. Mason the second payment of $20,032.50. By email, I communicated I would like conditional lien waivers for the first 2 payments totaling $30,000 at that point in time.
Did you receive those lien waivers between the date of request on June 13th and the date you received the claim of lien on August 10th of 2018?
I did not.
Last question at this point in time. When you and Mr. Mason decided to part ways, was there a formal written agreement or change order executed between you and Mr. Mason?
There was not, other than our email exchanges back and forth.
You had some email exchanges back and forth that we previously marked as Defendant's Exhibit 22. Is that correct?
That's correct.
And then Exhibit 22 reflects the only agreement concerning the parting of ways. Is that correct?
That's correct. There's nothing other than these emails.
And that's actually, it says 1 of 5 pages. Is that correct? But there's only 2 pages that are part of this exhibit. Is that correct?
That's correct.
Now, there's some reference down there about the gutters that you mentioned. And there's another issue here concerning siding. What does that pertain to? Down at the bottom of the first page.
In the original scope of the contract, Mr. Mason, was to install a sliding glass door on the lake side. And part of that, the front fascia, the aluminum siding was entirely removed and then discarded. And so there was no, it was his scope to reinstall that in the condition it was before the door was cut out. There was no scope to change out the siding, no provision for that. And so and on this date when we were parting ways, there was no front fascia on the property. There was no aluminum siding reinstalled. There was nothing there. It was just exposed. The OSB board was exposed. The door was installed, but if you looked at it from the water side, you would just see the brown board there.
The board that would go under the fascia, is that correct?
Yeah.
There's a reference here about a roof boot at the bottom of that first page. What does that concern?
There was a mention by Mr. Mason to me that as he was on site, that when one of the rains occurred, he noticed a leak coming through a roof boot, and said there was no choice but to fix the boot. And so I was inquiring, since I wasn't able to ever leak test it or observe it when it was raining. So I was inquiring as to whether the boot was installed and the leak was resolved. The leak is addressed.
At the top of the second page, there's discussion about dimmer lighting. What does that pertain to?
In about June 10th or June 8th, that time frame, Mr. Mason asked myself and my wife to come up to the home and meet with the electrician about where to place items. And so the dimmer light, we discussed dimmer lighting, and that was related to that.
But that pertains to items that Mr. Mason was to conclude as part of the separation of waste, correct?
Correct.
And then the second paragraph there is plumbing. We talked about toilets, but there's other things that needed to be connected by Mr. Mason as well. Is that correct?
Correct. From memory, there was the showers, 2 toilets, 3 sinks, kitchen and 2 bathroom sinks, hot water tank, provide the water softener and install the water softener, the exterior shower. So those, and the connection of the main water lines in the crawl space to the well pump.
And the dishwasher in addition.
Thank you. And the dishwasher in addition.
And the items that you've discussed and are the reason that for the holdback, is that correct?
That's correct.
Could you tell us what gave you an insecurity that these items might not be completed?
Well, just the fact that there was a demand for the final payment, and it just appeared that Mr. Mason may not come back at this point in time. And so that's why my wife and I undertook to get quotes for both the remaining electric and the remaining plumbing to just know the value if we would have to undertake that ourselves, and that would be equal to the holdback.
And then between the date of this memo or email, which is Exhibit 22, and the date that you received the lien, were these items completed by Mr. Mason?
They were not.
Was anything completed by Mr. Mason?
They were not.
Were anything completed by any subs working under Mr. Mason?
None, nothing.
Nothing further at this time, Your Honor.
Any recross, Ms. Fisk?
Yes, Your Honor. Mr. Jaros, I want to assume that maybe you misspoke just now when you answered that last question. Mr. Thompson asked you if any of the work that you held back your $69.95 for was completed by Mr. Mason or his subcontractors. There was work that was completed, correct?
Correct. I thought Mr. Thompson had said by that date and the date the lien was filed.
Okay, well, I might have misunderstood that. I just want to be clear. After you took over the project in mid-July, Mr. Mason and his subcontractors did come back and finish certain aspects of work, correct?
Correct. In August of 2018, they did.
After you completed your scopes of work for flooring and other things, correct?
Correct.
And so Mr. Mason's electrical contractor came back, right?
Yes.
And an inspection was had and it was passed in August, correct?
It's my understanding, yes. I wasn't there.
And the plumbing contractor came back and set all of the fixtures, installed all of the faucets, etc. And that work passed inspection in August as well, correct?
Yes.
And that was the bulk of that $69.95, was it not?
Right. The plumbing was the bulk of it. Right.
Thank you. Now, again, all of that work was waiting for your work to be finished first, correct?
Again, the timing issue, I'm not 100% certain what has to come first, but not being a general contractor myself, but.
Okay, fair enough. Fair enough. Now, I want to look back at Exhibit 22 that Mr. Thompson referred to. This is the email exchange that you referred to. And I just want to confirm something. So this email exchange looks like it starts back on, and I don't have pages 3 through 5, so I don't know when it exactly started, but at the bottom of page 2, it starts with Mr. Mason's email to you of July 12th, correct?
Yes.
And there's a list of things there from Mr. Mason indicating items that still need to be completed will be completed and giving you discounts, correct?
Correct.
And these are agreed upon credits that the two of you spoke about and were in fact given to you, correct?
Correct. We were going back and forth negotiating the final at this point.
Okay, understood. But you agree that a various number of credits were in fact given back to you on this project, correct?
Correct.
And generally speaking, looking at this list on page 2 of Exhibit 22 at the bottom from Mr. Mason, these are almost substantially exactly what was agreed to. Is that fair?
That's fair.
Okay, so you're getting a credit for the bathroom light fan issue, right?
Yes.
Demo of the porch concrete was credited back to you, correct?
Correct.
Floor coverings and labor of $6,000 was credited back to you, correct?
Correct.
Painting at $3,200, but was later agreed to be $3,700, right?
I know it was increased. I don't remember the exact value, but.
Does 3,700 sound correct?
I would have thought a little lower than that, but it was above 32.
Okay. And then you were given credit for $700 for that exterior door, correct?
Correct.
Okay. Now let's go to page 1 of Exhibit 22. In the middle of the page, you write an email to John Mason on July 13th, 2018, correct?
Correct.
And the first sentence of your email reads, "Thanks for your email, as we also want to work this out so we can salvage some of the summer and you can focus on your other projects." You're essentially cutting Mr. Mason loose from the balance of those things that you had agreed you were going to take over in his email on the other page, correct?
Correct.
Okay, so you're assuming responsibility for the rest of the project with the exception of the work by the subcontractors and a few things that Mr. Mason needs to come back and do, correct?
Correct.
Now you mentioned, Mr. Thompson was asking you questions, that the pace of this project was slow. This project started at the end of March. I think March 29th to be exact, work started on your project, correct?
I'm not certain when it started, but I just know when the contract was signed and I sent payment on March 16th. But I'm not certain when it started since I live about an hour away.
Okay, that's a good point. You live in Ohio, correct?
Correct.
And this is a summer cottage that you visit on the weekends in the summer, or maybe spend some time in the summer, right?
Correct.
So you weren't on site every day of this project in 2018, right?
Correct.
Okay. And then you took over, as we established, in mid-July. That's 3.5 months, right?
Yes,
But your position is that the pace of this project was moving slow, right?
yes, if I, could I,
And earlier I asked you if this was an extensive amount of remodel, and you agreed with me, right?
I agree.
Okay, thank you. So you mentioned also when Mr. Thompson was asking you questions that the intent with respect to your $6,995 holdback was contingent on inspections clearing. Those were your words. Inspections were passed, correct?
It's my understanding, yes, they were passed in late August.
And you ended up with a certificate of occupancy, correct?
Correct.
Okay. But at the time that the claim of lien was filed, and on August 1st, it wasn't just $6,995 that was owed, right? There was still an additional amount. In fact, the lien was over $19,000, right?
It was 19, yes, correct.
Okay, so it wasn't just the balance of this contract price that you held back contingent on completion of subs. It included a lot of work that had already been completed at that point in time, correct?
Yeah, on August 1st. On August 1st.
Okay, thank you. Let's talk about the siding for a second. You mentioned that, I think your testimony was that Mr. Mason and his workers pulled the siding off and disposed of it. You don't actually know that that's what happened, do you? Did you see them dispose of this siding?
Well, I saw it in their trailer, so I didn't actually see them physically take it to the dump, but I saw it in the trailer that's accumulating debris and then hauled away. It was subsequently hauled away.
Why didn't you stop them at that point if you saw it in the trailer and said to them, that's supposed to be reinstalled, take that back out, stack it in the yard? You didn't say that, did you?
I didn't say that.
Okay, thank you. And you didn't pay Mr. Mason any money at all or any kind of contract change to install new siding, did you? And he didn't charge you for that, correct?
Did not. He
Okay.
subsequently did, invoiced me.
He invoiced you to purchase new siding?
Or he gave me an estimate to put the siding back up.
But that's not work that ever was done, nor was it work that you ever paid for, correct?
Correct.
Thank you. Now, this roof boot issue, this leak, it was fixed, right? You don't have a leak in your roof, do you?
There is a small leak that's coming in the bedroom still. We can't determine where it's coming from. So there is still this, the ceilings are cracking. The drywall cracked today still.
Okay, let's talk about this roof for a second. Have you ever notified Mr. Mason that there was an ongoing issue with a roof leak?
I've not.
With respect to the drywall, you mentioned that there are some cracking issues. I think in some of your responses and your pleadings, you mentioned that the drywall cracks appeared in September of 2018. Is that accurate? That's your representation? Okay.
We stayed there at that point in time around the end of September.
Okay, thank you. So with respect to that drywall cracks, if they're appearing in September of 2018, this is only a month, 2 months after Mr. Mason's off the project, right? And it's actually several months after drywall was completed, correct?
Yes. Yes.
Okay. Did you ever contact Mr. Mason or the drywall contractor to let them know that there were some cracking issues with the drywall?
We did not.
Okay. So with respect to drywall cracking, well, strike that. Let's talk about the dimmers for a second. You asked for dimmers to be installed in the kitchen, correct?
Right.
You knew, though, that it was your responsibility to purchase those dimmers. Is that right?
I believe that refreshes my memory.
So if the dimmers weren't available to be installed at a point where the electrician is on site, they're not going to get installed, right?
Right.
And you actually were communicating directly with the electrician that was hired by Mr. Mason Christopher Clark, known as Topher Clark from Liberty Electric. You communicated with him directly, correct?
Yes, in some instances I did.
You had his cell phone number and actually texted with him, right?
Correct,
And you talked about the dimmer switches with Mr. Clark, correct?
correct.
In fact, he said, sure, I'll do that. Just have them available and I'll make sure they get installed, didn't he?
Right,
And
correct.
okay, thank you. Did you ever, if this was still an outstanding issue, did you ever text Mr. Clark and ask him, hey, I got these dimmers available, they're at the house, you can come back and install them? You didn't do that, did you?
I may have done Mr. Mason because I was buying the product that I was supposed to buy and accumulated everything in the outdoor shed. So I was always staying way ahead of Mr. Mason and always saying, here's all the product, ample, I want to say weeks ahead, maybe months ahead.
I appreciate that. That wasn't my question though. If at some point after all of the work is done, Mr. Mason's off the project, the electrician's off the project, but you discover, you know what, these dimmer switches are still, they still haven't been installed, you could have texted Mr. Clark, correct? Because you did it throughout the project, right?
Right.
And you didn't do that, right?
I thought I did. I thought I texted Mr. Clark
Okay.
or Mr. Mason, one or the other.
I have no other questions at this time, Your Honor.
Let's take about a 10-minute